formula. Please note this, my lord. This only Sardar could have spoken. And now, my lord, it has proved to be, my lord, prophetic. He said that after all, neither Sheikh Abdullah nor Gopala Swami was permanent. The future would depend on the strength and guts of the Indian government.
This is not a political.
And if we cannot have confidence in our strength, we do not deserve to exist as a nation.
If I may just seek the permission of the learned Solicitor General, we were all told on 3rd of July to file all documents.
Again,
there's nothing to be filed thereafter.
Continues it.
This is administrative.
Mr. Surya Singh,
Who were given, all of who were given.
Mr. Singh, let him continue. I mean, what's
This side patient.
No, when your side argued, there was no interruption from either the attorney or the solicitor.
Lord, many of them provided additional documents,
But,
additional judgments. We never objected.
These are well established. These are well known.
Why such sensitivity over some statement
Because
which comes
Because no,
may not be palatable?
also, Mr. Singh,
the
Mr. Singh, equally we know that when we decide the matter, we have to give primary importance to primary sources,
Yes.
such as the statutes, the instruments of accession. These are other documents which he is relying on. The extent
was
of,
dead. Nurani was not even born when all this happened.
it extract put in a list of dates.
I did object to Nurani. It's a one-sided
no,
picture.
your nodal counsel argued that he received it Sunday evening.
I'm sorry.
Your nodal counsel, he agreed in the morning that he received it long back, but he did not circulate it amongst you.
On Sunday, last Sunday.
I'm saying that there are extracts from a book in a list of dates. The book is not on record. It's not a document before your lordship.
We'll give more copies of the book.
That's not the point. I mean, this can just keep getting enlarged. I'm only saying that let's stick to the record. We were
Lord, if
told-
AG Nurani can be read, even a newspaper can be read. I'm sorry, I'm saying this with seriousness. I have read AG Nurani. It is a one-sided. But we didn't object. My lord.
That's all right, Mr. Solicitor, you don't have to go that far.
No, my lord, I'm on page 40.
Mr. Singh, all that this really indicates, it's not like, conclusive evidentiary material.
Yes, my lord.
This is used to demonstrate that there were different points of view, different perspectives which were flowing in at that time.
A historical perspective of what people
It's a
felt at that particular
There
time.
are several
And
things
in
mentioned
internal
by
dialogue that was
I would-
taking place, where one side was expressing one view, the other side was strongly opposed to it. Ultimately, we have to interpret the provision of the Constitution.
Exactly.
How this all came about,
This
that's
is
all
an
that we are
aid
concerned.
of-
Sibal, you also referred to certain
I
documents.
mind whether this going on, but I mean,
That's all right. These documents give us some
That's right.
air of the background,
I-
of different perspectives to the
Lord,
background.
Several new facts were stated. I didn't object because I didn't want to trivialize the dialogue. This is the constitution bench we are
Solicitor, please proceed.
So kindly come to page 44.
If I not can be read in this.
Yes, sir. Lord, 43 bottom. In the course of discussions regarding federalism in India during the Constituent Assembly, Jaspat Roy Kapoor, representing United Provinces, commented, I only wish that Kashmir should also
No, you are reading page? 44.
Page 43, last date, my lord. This is Constituent Assembly debates, CCD, my lord, document volume 8, PDF, my lord. I've quoted for your lordship's easy reference.
Just put the back.
In the course of discussion regarding federalism in India during the Constituent Assembly, Jaspat Roy Kapoor, representing United Provinces, commented, I only wish that Kashmir should also have been brought in on the same level as other states, but unfortunately, much to our dissatisfaction and chagrin, if I may say so, this would not be done. This is a delicate subject, and I'll not say anything more on this. But please read this, my lord, now. This is very, very important, and in my respectful submission, the answer, my lord, lies here. What happened to Jammu and Kashmir, its sovereignty, external, internal, my lord, the difficulty is the petitioners are confusing, in my understanding, internal sovereignty with autonomy. external sovereignty, my lord, nobody can dispute that it is with the Union of India. Internal sovereignty in the facts of our case and in the constitutional structure which we have accepted would mean autonomy of the federating units. And which autonomy is there with every state? There are none.
It's actually there with every institution.
Every institution is autonomous. So that's not
I mean,
internal.
we have the autonomous authority to decide a constitutional issue.
Commission.
But we can't say that internal sovereignty rests with us. We are an independent autonomous institution under the
They are
Constitution.
confusing the word autonomy with internal sovereignty. There is no internal sovereignty.
Except that, Mr. Solicitor, to paraphrase their argument fairly, what they are saying that, look, we gave up external sovereignty, there's no doubt about it. They say that we have acceded to the Indian Union, that's irrevocable. But they said that the course of events, the adoption of 370, would indicate that while there was a giving up of external sovereignty, a modicum of internal sovereignty, which was exercised by the then Maharaja, that was not ceded to the Indian Union. That seems to be the line of.
That's the submission, madam. And my respectful.
And therefore, they are relying on various judgments of our court to indicate Indira Nehru Gandhi versus Rajnayan, to indicate that sovereignty has an external component, it has an internal component also.
Different context, but I'll assist your lordships on that.
By and by, in your turn, you can explain
Yes,
that
yes.
that line of. We are really on the list of dates. You can go ahead. Yes.
25th 11/1949, Yuvraj Karan Singh issued a proclamation for the state of Jammu and Kashmir. I have given the pagination, by which he declared and directed that Constitution of India, shortly to be adopted by the Constituent Assembly of India, govern the constitutional relationship between the state and the contemplated Union of India, and shall be enforced in the state by him, his heirs and successors, in accordance with the tenor of its provisions. The same proclamation is worth quoting in full. Whereas with the inauguration of the new constitution for the whole of India, now being framed by the Constituent Assembly of India, the Government of India Act 1935, which now governs the constitutional relationship between this state and the Dominion of India, will stand repealed. Your Lordships may kindly recall the instrument of accession was under Government of India Act and subsequently Independence Act. And whereas in the best interest of this state, which is closely linked with the rest of India by a community of interest in the economic, political and other fields, it is desirable that the constitutional relationship established between this state and the Dominion of India should be continued as between this state and the contemplated Union of India, and the Constitution of India as drafted by the Constituent Assembly of India, which includes duly appointed representatives of this state, provides a suitable basis for doing so. I now hereby declare and direct that Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, but please mark this, this is where, my lord, they are highlighting and I will have to meet with, insofar as it is applicable to the state of Jammu and Kashmir, govern the constitutional relationship between this state and the contemplated Union of India, and shall be enforced in this state by me, my heirs and successors, in accordance with the tenor of its provisions. That the provisions of the said constitution shall, as from the date of its commencement, supersede and abrogate all other constitutional provisions inconsistent therewith, which are at present in force. This is beyond any instrument of accession or merger. This is accepting supremacy of our constitution and surrendering the sovereignty to the constitution, where the sovereign is we, the people of India. No.
Of course, when he made this proclamation on 25th of November 1949, this is on the same day as Dr. Ambedkar's last address to the Constituent Assembly, the famous address to the Constituent Assembly. So by this point of time, the entirety of the Constitution had been formulated,
Including 370
right?
and
Including 370.
and Article 1.
Therefore, when he makes this proclamation in the light of 370, which also is before him,
Correct.
right? There can't be any doubt about
There
that.
cannot be any doubt. I bow down.